Okay, good evening. Thanks very much for joining us in person, those of you who are in the room, and thanks very much to all the colleagues who are joining us online. We have about 100 online participants for this event. This is my colleague, Professor Kontouris, will introduce.
Thank you very much, Professor Mantovalu. Good evening to you all from UCL Laws here in London. And also good morning to some of you, because we are being joined via Zoom by a number of colleagues and members of the public who are joining us from across the Atlantic, we've noticed. It's the first event for this year organized by the Labour Rights Institute and the Human Rights Institute here at UCL Laws. The event is, of course, extremely topical given the recent decision of the governing body of the ILO to make a reference to the ICJ. It's extremely important for the community of labor lawyers, but I will share with you a little secret. Actually, we owe the idea of this event to our public international law professor, Martin Paparinskis, who was the first, as soon as we had the news from the ILO GB, to say this is really new and this is really important. We should do something together by way of a public event. So here we are with an outstanding panel of experts. I will only introduce Professor Virginia Mantovalu, Professor of Labor Rights and Human Rights here at UCL Laws, and also the director, one of the directors and founders of the Human Rights Institute and of the Labor Rights Institute. And she will take over from now and introduce the event and the rest of our panel. Thank you very much.
Thank you, Nicola. So we have a very distinguished panel of experts that will talk to us tonight about this new development, the advisory opinion that was requested by the International Labour Organization from the International Court of Justice. Major development with a lot of new things for both international lawyers and labor lawyers to learn and to consider. Our distinguished panel of experts, I will introduce our speakers first of all, but in the order that they will speak. Professor Tonia Novitz, first of all. Tonia is Professor of Labour Law at the University of Bristol Law School in the UK. From 2019 to 2023, she was chair of the steering committee of the International Labour Law Research Network, the LLRN, which links 83 research centers worldwide. We're part of that as well, the Labour Rights Institute of UCL. Tonia has published extensively on issues of labor law and other areas of law, and her publications have been cited in judicial decisions of the Supreme Court of Canada, the UK Supreme Court, and elsewhere. I think her first monograph, I believe, was the International and European Protection of the Right to Strike, which was published by OUP in 2003 and is a classic in labor law scholarship. And Tonia also recently co-edited a book on the right to strike and international law, together with Jeff Vaught, Janice Bellas, Lance Kompa, Keith Ewing, Lord Hendy, Klaus Lorcher, and Klaus Lorcher. So this was published in 2020 by Hart Publishing on the right to strike and international law. Our second speaker will be Lord Hendy KC. Lord Hendy is a barrister and KC at Old Square Chambers. He is with no doubt best known for his work in industrial relations and employment law. He has appeared both in national courts and in supranational courts, the European Court of Human Rights, and in other supranational fora, in some of the most important cases in individual and collective, particularly employment law, collective labor law. He sits also as a labor peer in the House of Lords, Lord Hendy. And last but not least, we're extremely fortunate to have John as an honorary professor here at UCL since 2014. So he's also a colleague of ours at UCL. Finally, our colleague again, Professor Martin Paparinskis. Martin is Professor of Public International Law here at UCL in the Law Faculty. He has a long and distinguished career in international law, but I will only mention here that he's a member of the United Nations International Law Commission since 2023 and the chair of its drafting committee. Martins has also appeared before the International Court of Justice. He will be our third speaker today, our public international law expert. Each of the speakers will speak for about 10 to 15 minutes, and then there will be time for questions. Those of you who are here in the room, feel free to raise your hand when we ask when it's time for questions. Those of you who are attending online, please feel free to type your questions on the Q&A function of Zoom, and we will read them to the speakers. We will collect them in the end and read them and address them to speakers. So Tonya has some PowerPoint slides. Tonya, over to you.
So thank you very much for inviting me to be here. I'm going to, by agreement with Professor Lord John Hindi, KC, I'm going to set the scene for the ILO 2023 reference to the International Court of Justice. So I thought that it might help to start by just showing you the terms of reference which were agreed by the ILO governing body on the 10th of November 2023. So there was a special session held that day, which was much disputed by the employers group. They didn't want it to be held, and immediately the day after, they had set up their own special session, which was to be about dispute settlement resolution more generally. So it is very interesting that the governing body actually managed to adopt this resolution and did so through a fairly sizable majority. Okay. So there was a coalition of members of the workers group here and the governments which achieved this. There is only one question which is being put to the International Court of Justice, and this is not a broad question just about whether the right to strike exists. We know that it does, and that it's written into certain international instruments. So, for example, it is there in the International Covenant on Economic, Social, and Cultural Rights of 1966. It's there in the European Social Charter. The question is whether, for the purposes of the ILO, it can be understood to be included in ILO Convention number 87 on freedom of association and protection of the right to organize. Now, there was talk of a second question, which was about the competence of the Committee of Experts to interpret Convention number 87 in this way. But ultimately, and a lot of people, including John and myself, argued against that beforehand, it is just focused on this one question. And the governing body instructed the ILO Director General to make the reference with suitable documentation. It's interesting that the letter was sent on the 13th of November. So it was handled very swiftly indeed, with the idea that the ILO, the International Labour Office, will follow up with a dossier with suitable documentation afterwards. There was also an instruction that the ICJ be requested to enable participation of employer and worker groups, which are recognized at the ILO, which is important in terms of the tripartite form of decision-making at the ILO. And what we know as of today, this afternoon, is that the ICJ has approved that. So there will be, for example, submissions from the International Trade Union Confederation, the ITUC, the World Federation of Trade Unions, the WFTU, and the Organization of African Trade Unions, UNITY. So there was also a request that the matter be expedited. And what we know is that those submissions are to be made initially by the 16th of May, with the opportunity to respond to submissions by the 16th of September. So it does look like this might be going quickly, although the ICJ has held off for the time being and hasn't said that this will actually be expedited. So what did I think I could tell you about? I want to talk to you a little bit about what the International Labour Organization is, why tripartism is so important. Secondly, I thought I'd tell you something about how the ILO adopts standards and normally supervises these, what is Convention number 87, what supervisory bodies are relevant here, and then what is the history of the dispute regarding ILO Convention 87. And here I'm going to cover the 2012 employer group-led walkout, the 2015 agreement that wasn't really an agreement that worked, and ongoing tensions. So the ILO was created in 1919 by the Treaty of Versailles, and it is the one key international organization that survived the Second World War. It set up an innovative structure for an international organization. So it is tripartite in the sense that there is structured representation of employers and workers within decision-making. At the International Labour Conference, each member has a state delegation, but it consists of 2 government, 1 worker, and 1 employer representative with some deputies. And they can only adopt conventions and recommendations like Convention number 87 by a 2/3 majority. So there's a lot of wrangling in terms of the text of a convention. It's going to be very general and broad, and it's going to be highly disputed along the way. In terms of the governing body, which decides the International Labour Conference agenda, all the budgetary matters, for example, elects the ILO Director General, that consists of 56 members, 28 government, 14 employer members and 14 worker members. So the ILO is a UN agency. It places great emphasis on freedom of association through a number of declaratory instruments. The Declaration of Philadelphia was incorporated into the Constitution. And then in the 1980s and 90s, there became pressure on the ILO to rationalize its activities. And it started to identify core ILO conventions. Now, freedom of association and protection of the right to organize Convention number 87, along with Convention number 98, have become core ILO conventions. And you can see them referred to, for example, in EU and other trade agreements. It is a mark of the importance of freedom of association that there is ongoing recognition and declarations of 98, 2008, 2019, and even the covenants of 1966 say that their provisions on freedom of association, collective bargaining, and right to strike are not to prejudice obligations arising under ILO Convention 87. So it's an important convention. In terms of supervisory mechanisms, initially ILO competence was contested, and there were various disputes that came to the Permanent Court of International Justice on 6 occasions between 1922 and 1932. It is evident that the ILO had to settle into its own supervisory procedure. In theory, only the International Court of Justice can interpret ILO conventions. In reality, there is an ongoing supervisory mechanism in place since 1926. There is a committee of experts that looks at the application of conventions and recommendations and will provide conclusions. Those go to a conference committee, which is tripartite on the application of standards, the CAS. And then a selection of cases goes to the International Labour Conference with the possibility of disciplining states through mention in a special paragraph. There are complaints procedures, which I won't go into now, but it's also important to note that 2 crucial mechanisms were set up after the Second World War. One was a fact-finding and conciliation commission on freedom of association, which operates at the state consents. And that was very important, for example, in terms of South Africa. There is also a tripartite governing body committee on freedom of association, which was established in 1951, and by 1955 was very clear that a right to strike emerged. The right to strike was said to be derived from the ILO Constitution, also from Convention number 87 and the protection of activities of trade unions, and also from Convention number 98. And over time, the ILO Committee of Experts accepted the views of the Committee on Freedom of Association. The Committee on Freedom of Association is truly tripartite. It has 3 government, 3 worker, 3 employer representatives, and a legally representative chair. So a legally qualified chair who can guide the discussion. So it is truly tripartite in terms of a compromise on what the right to strike should be. And so since 1955, we have had a tripartite committee which has informed the Committee of Experts' decisions and has made clear that the right to strike is an essential means through which workers and their organizations can promote and defend their economic and social interests. And it also nuances the extent to which one can engage in political strikes and what restrictions can be placed on strikes. And these have been set out in the Committee on Freedom of Association Digest and an extensive report of the Committee of Experts. So this is both an expert-led process and it's a tripartite-led process, and there's detailed jurisprudence, I would call it, on the right to strike at the ILO. Now, the ILO employer group was very enthusiastic about the right to strike when it was being applied in a Cold War context. For example, when Polish trade unions wanted to exercise the right to strike. They became much less enthusiastic in the wake of the Cold War. So by 1994, we had the first comments and objections from the employers group in the Conference Committee on the Application of Standards, the CAS. Those rumbled on, especially as certain states, for example, Germany, became concerned that their system of excluding all civil servants from access to the right to strike was being criticized by both the Committee of Experts and the Committee on Freedom of Association. But the big move that took place was the employers group walkout from the CAS in 2012. And I think the reasons for that are worth exploring. So the employers group said, we think the right to strike should be discussed on a tripartite basis rather than left to the experts. That's an interesting view, given that the Committee on Freedom of Association is tripartite and led on the standard setting. It's ignoring that. They had concerns in particular about detailed jurisprudence on political strikes and essential services coming from an instrument that did not explicitly mention the right to strike only trade union activities. And they objected to the influence of Committee of Expert findings in other courts, particularly, I think, although they never said this, the European Court of Human Rights, which in Demir and Beikara had just recognized that collective bargaining was an essential aspect of freedom of association under Article 11 of the European Convention on Human Rights. So they demanded tripartite political discussion in the CAS, and they didn't want the Committee of Experts to take charge. The ITUC responded, and in particular, I think we have to thank Jeffrey Vogt, who is the legal advisor at that time, for really energizing opposition to the employers group. Now, this was a real challenge to the tripartite system of the ILO, that the employers were no longer cooperating. They were just walking out of a committee, and no cases on the right to strike could then go to the International Labour Conference. And so what Jeffrey Vogt and others did is they mobilized in drafting a legal opinion. And John and I were very fortunate to be included in that process. In the end, it was a 122-page document, and the employers group responded with an online brief of 13 pages. So, I mean, the preponderance of opinion was very much one way rather than the other. And there was mobilization to try to refer the case to the International Court of Justice. Now, the employers group were very much opposed to that. They wanted to explore every other possibility. The ITUC kept on and held a day of action in January of 2015, and at the same time had put in submissions in opposition to the employers group and some key proceedings. For instance, before the Canadian Supreme Court in the Saskatchewan case. And the employers group seemed to capitulate. They reached agreement in a joint statement in 2015. They said they acknowledged the right to strike, and they acknowledged the mandate of the Committee of Experts as the Committee of Experts had stated this. There was a much more emphatic government statement which emphasized the importance of the right to strike and the importance of the supervisory findings of ILO bodies. But the International Organization of Employers, which acts as a secretariat for the employers group, has never recognized that the right to strike stems from ILO Convention number 87. And they have kept on resisting. So they've resisted findings on the right to strike. Even after 2015 in the CAS, they have started opposing the tripartite process of finding breaches of the right to strike in the Committee on Freedom of Association. And this is despite mobilization by the human rights bodies in a statement of 2019 and the views of the UN Special Rapporteur on freedom of assembly and association. So that is where I'm going to stop. Here are a few references that might be interesting to those of you who want to follow up on the background to that dispute.
Thank you very much, Tonya. And now John will talk to us for about 10-15 minutes. Lord Hendy.
Thank you very much, Virginia. Thank you, Tonya, for that introduction on background to the subject this evening. What I wanted to do is to sort of sketch out what I thought might be the principal battleground within the ICJ on the question that's been referred to it. I should make absolutely clear that the International Court of Justice has determined that the groupings that Tonya mentioned, including the International Confederation of Trade Unions, is entitled to submit a statement or statements to the court, which means that it will effectively be a party. But none of those, well, at least the ICTU has not decided who its council or representatives will be. That's still a matter for discussion. Whether it'll include Tonya and myself, I've got no idea whatsoever. So what I'm offering you this evening are just some personal thoughts from my own perspective, looking at it from the outside. It all may change when the ICTU decides who it wants to draft the statements and to represent it in court. So this is just very much a personal perspective from myself. On the, I think the 6th of November, 16th of November, the International Court of Justice, in response to the application to it from the ILO, made some directions. And amongst the directions were that the various bodies, the ICTU and so on, as Tonya's mentioned, should be entitled to submit statements, but they also fixed some dates. So to give you some idea of the time scale of this, they fixed the 16th of May 2024 as the time limit for written statements, and the 16th of September 2024 is the time limit within which parties can present written statements, written comments on the other side's written statements. So we're not looking at a speedy procedure here. And when the case might actually come before the International Court of Justice is obviously going to be significantly longer than that. I think we're probably looking at 2025. So look, the question, there are some preliminary issues which I won't take up time with now. I should just mention that the ICJ, although they've made directions, doesn't mean that they're obliged to hear the case and consider whether they should exercise their advisory jurisdiction. They always have a discretion not to do so. I think it's most unlikely that they'll exercise it in this case. They also have a discretion to reformulate the question if they think that it doesn't get to the heart of the issue. Again, because of the simplicity of the question here, which I'm just about to read to you, I don't think that that's likely. So the question that has been referred by the ILO is this: is the right to strike of workers and their organizations protected under the Freedom of Association and Protection of the Right to Organise Convention of 1948? That's to say, Convention number 87. Now, in that question, although it's very clear, there is a hidden issue, which I just mentioned now. I don't think I'm giving any prizes to the employers, because I'm absolutely sure they'll be onto this one. But it does presuppose that the right to strike, if it exists at all, is that of workers and of workers' organizations, which is what the ILO call trade unions. That distinction has not been an issue of debate within the ILO over the last 70 years, but it does raise its ugly head, because, as all the law students here know, in February this year was the case of Barris and Turkey in the European Court of Human Rights, which held that the right to strike protected by Article 11 of the Convention only protects the right to strike when exercised by a trade union and not by workers who are not in a trade union. Now, what the ILO will make of that in due course, well, I can only guess. I mean, well, I mustn't digress. Anyway, if that argument were to be put forward to the ICJ, I would think that the ICTU and the other workers' bodies might well respond in three ways. They might say that it's a matter for the ILO bodies, the Committee of Experts, Committee on Freedom of Association, governing body, and so on, to decide which workers or trade unions the right to strike under Convention 87 is bestowed upon. The question for the ICJ is surely whether there is a right to strike inherent in Convention 87. And secondly, the ILO bodies have so far had no problem in deciding the limitations by class of person to whom the right to strike applies. And indeed, like other conventions conferring trade union rights, Convention 87 applies to both workers, for example, Article 9, well, no need to go into detail, and to workers' organizations, for example, Articles 6 and 7. And what's sauce for the goose is sauce for the gander. The rights under Convention 87 extend not just to employers' organizations, but also to employers. So the right to lock out and so on. Well, now, having mentioned those by way of preliminary, let's come to the essential objection which the employers raise against the right to strike under Convention 87. And it's essentially this: given the absence of any reference to a right to strike in the actual text of Convention 87, the internationally accepted rules of interpretation require the convention to be interpreted without implying a right to strike. By the same token, though Convention 87 protects the fundamental right of freedom of association confers no other right in relation to a trade union or an employers' association beyond mere membership. The UK Labour law students here will, of course, find an echo of that very argument in the case of Wilson and Associated Press in 1996 in the Judicial Committee of the Supreme Court, an argument which was absolutely rejected when the case came to be heard in the European Court of Human Rights under the name of Wilson and Palmer in the United Kingdom in 2002. Nevertheless, the argument is one which clearly could be advanced by the employers. Well, now perhaps I should have started with the material provisions of Convention 87. As you've heard, its title is the Freedom of Association and the Right to Organise Convention. So freedom of association is in the very title of the convention itself. We haven't got time now to analyse all the provisions of the convention, but I just want to read to you one specific article, Article 3. It provides, 1, workers and employers organisations shall have the right to draw up their constitutions and rules, to elect their representatives in full freedom, to organise their administration and activities, and to formulate their programmes. 2, the public authorities shall refrain from any interference which would restrict this right or impede the lawful exercise thereof. Now, there are other articles which bear on the question that we're looking at, but time doesn't permit. So the employers are right. There is no express right to strike stated in Convention 87. But as you've just heard, Article 3.1, which unlike 3.2, contains rights directed at the world in general, including employers and employers' associations, and not just directed to state bodies like Article 3.2. Article 3.1 contains the following 3 elements. 1, the right of unions and employers' organisations to draw up their constitutions and rules. 2, the right to organise their activities. And 3, the right to formulate their programmes. Now, clearly, the argument of the workers' groups in the ICJ will be that that necessarily implies the right, amongst other rights, the right to strike. Now, the central basis of the argument before the ICJ will inevitably turn on the Vienna Convention on the Law of Treaties, 1969. We know from the jurisprudence of the ICJ that it always looks to the Vienna Convention to see what tools are available to interpret debated or contentious provisions of international treaties, of which, of course, the Convention 87 is one. Now, again, we haven't got time to review all the relevant articles of the Vienna Convention, but Article 31 is probably key, and I'll just read a couple of passages from it. 1, a treaty shall be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty in their context and in the light of its object and purpose. 2, the context for the purpose of the interpretation of the treaty shall comprise, in addition to the text, including its preamble and annexes, A, any agreement relating to the treaty which was made between all the parties in connection with the conclusion of the treaty, B, any instrument which was made by one or more parties in connection with the conclusion of the treaty and accepted by the other parties as an instrument relating to the treaty. 3, there shall be taken into account, together with the context, any subsequent agreement between the parties regarding the interpretation of the treaty, application of its provisions, any subsequent practice in application of the treaty, blah, 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 and finally, any relevant rules of international law. Now, Article 32 gives a supplementary means of interpretation, which allows, amongst other things, reference to the preparatory work of the treaty, but only where the Article 31 principles would leave the meaning ambiguous or obscure, or lead to a result which is manifestly absurd or unreasonable. Now, from that, I draw 4 principles And I'm going to go through each one of them in relation to the question. Have I got time to do that? Okay, well, the first principle, it seems to me, is a requirement to determine what, and I take this phrase from a previous ICJ case, what the plain and obvious meaning of the words in question are. So what is the meaning of a trade union right to determine its activities, or example, unless such interpretation would lead to something unreasonable or absurd. And that applies equally to drawing up constitutions and rules. Now, given the usual nature of trade union and employers associations, rules and constitutions, it seemed reasonable to conclude that their governing documents are free under Convention 87 to set out the structure by which they'll make and implement decisions, their purposes, and if not all, then some of the ways in which they'll seek to achieve their objectives, including, as most trade unions in Britain do, the rules regulating such industrial action as the union will support. Now, if one considers what the contrary submission to that would be, it would be that there's no right under the Convention 87 to have a constitutional rule authorizing any specific kind of activity, since none are specified by Convention 87. Well, once you express the proposition in that way, you reveal immediately its absurdity. You can't construe a general right as having no effect in the absence of specification of particular rights, and a literal construction of the word simply cannot sustain an interpretation which negates any content being given to an express right. And that proposition seems to me to be even clearer in relation to the word activities. I mean, if you're not allowed to have a rule which, or if a union's not allowed to determine any particular activity which its members have decided under their constitution to indulge in, then Convention 87 has got no meaning at all. No activities, lobbying for new legislation, giving out welfare benefits to distressed members, pursuing personal injury claims on behalf of members injured at work and so forth. None of those things would be protected by Convention 87 if activities did not allow the specification of particular kinds of activity by the trade union. And the same logic appears to me to apply to the word programs. So unions are free to identify what their programs are, and that program could be, we're going to pursue collective bargaining in the car industry, and if we fail to achieve the objective £25 an hour minimum, blah, 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 then we will ballot the membership for industrial action. It seems to me, finally, on this first proposition, that the ILO bodies, having accepted the right to strike emanating from Convention 87, and domestic and regional courts likewise having accepted it, supports the contention that the ordinary meaning of the relevant words includes the right to strike. Now, the second proposition drawn from the Vienna Treaty seems to me to be that the interpretation must be done in the overall context of the treaty and its purpose and objective. Now, I know I'm running out of time and I don't want to curtail Martin's contribution, so I'm not going to indulge in this very much, but there's an awful lot of material to be drawn from Convention 87 and from the Constitution of the ILO, which makes clear that its purpose is the protection of workers, and in particular, the protection of workers through the promotion of the right to bargain collectively. After all, the founding declaration of the ILO post-war, the Declaration of Philadelphia, signed in May 1944, 3 weeks after the Soviets had signed the surrender of the German troops in Berlin, specifies in particular the right to bargain collectively. And once you've established that the right to bargain collectively is part of the context and purpose of the ILO and of the and hence of Convention 87, the right to strike must follow, because the right to bargain collectively, as has been said many times in judicial proceedings, the right to bargain without the right to strike is essentially no more than the right to beg. Now, the third proposition drawn from Article 31 of the Convention is to take into account any subsequent agreement, subsequent practice between the parties which establishes agreement and any subsequent instrument between the parties. Again, I'll deal with this very quickly, but the fact of the matter is that the Committee of Experts have, the Committee on Freedom of Association of the ILO have founded the right to strike on Convention 87 from as long ago as 1952 in hundreds of decisions since. The Committee of Experts expressed the same conclusion in its general survey in 1959, reiterated in every general survey touching on the right to strike since. And member states that have ratified Convention 87, of those, 138 did so since the CFA conclusion in 1952, and 116 since the Committee of Experts in 1959. It must follow that the parties to the ILO, who are the relevant parties here, have accepted and have agreed that the right to strike is properly founded on Convention 87. I can see, of course, there are going to be arguments about what amounts to a subsequent agreement, what amounts to a subsequent practice, who are the parties, and so on. But let's not go into that this evening. Fact of the matter is that the ICJ has in the past ascribed great weight to the body of jurisprudence established by supervisory committees of international treaties, such as the Human Rights Committee of the International Covenant on Civil and Political Rights in the Diallo case. But the ICJ have also said that they won't necessarily be bound by the conclusions they're reached. Finally, there's this issue of supplementary interpretation by reference to the travaux préparatoires. And that is, of course, permissible. But as I mentioned at the beginning, it's only permissible if the Article 31 meaning is ambiguous, obscure, absurd, or unreasonable. Now, given the wealth of ILO jurisprudence on the subject, the wealth of academic approval of the rationale, and the wealth of international, both domestic domestic courts all over the world and regional courts upholding the right to strike, not simply as an aspect of their particular constitutions, but as an aspect of freedom of association supported by the derivation from Convention 87, it seems to me that a submission that Article 31 meaning for Convention 87 is ambiguous, obscure, absurd, or unreasonable is simply untenable. But nevertheless, if we've got to go into the preparatory works, that's what's got to be done. But it does seem to me that the fact that the right to strike was not mentioned in the preparatory works, but the words activities was agreed, doesn't assist in the submission that there was that the intention of the parties was to exclude the right to strike. After all, it's equally supported by the submission that the inclusion of activities meant that it was not necessary to include the right to strike. It's true, and this is my final point, Virginia, forgive me. It's true that there were two motions at the time seeking inclusion of the right to strike, and they were rejected. But you can't draw from that the conclusion that the rejection of those specific proposals necessarily implied that the ILO was rejecting inclusion of the right to strike in Convention 87. Had that been their intention, it would have been so easy to include a few words in Convention 87, Article 2, to say activities, but this does not include industrial action. So, as I say, those are just my personal reflections on what might be the battleground in the ICJ. I suspect that the battle will be fought very intensely and on much wider grounds, or many other grounds in addition to those. But those will be some of the central ones, I suspect.
Excellent. Thanks very much. Thanks very much, John and Tonya, for these two brilliant labor law contributions. I personally would be very surprised if the International Court of Justice decided that this case on the basis of the preparatory works. So I have found the arguments very persuasive, unsurprisingly, given the wealth of materials that we have on the right to strike in international law, international labor law, and international human rights law, and national constitutional law. So now we'll hear from the public international law experts of our panel, and we are all very much looking forward to this. Martins.
Well, thank you, Virginia, and thank you, Virginia and Nicola, for organizing it. I think really in the fine spirit of academic camaraderie of UCL, of interlocking academic interests and all that. I do feel that perhaps the subtitle is a more than slightly modest one, because we already heard a great deal of highest caliber public international law engagement with the topic. But I will try to say a few things with perhaps a slightly more technical emphasis, not going into the substance of the labor law issue, but situating perhaps similar arguments in the international institutional law and international procedural law question. As my students in the audience will know, I'm not a great admirer of slides, so I will impose slides on you because there's quite a bit of text in terms of quotes and provision names, so I felt that it might be better for you to have it in the background. I will first very, very briskly say a few things about ILO and the ICJ that have really been covered, but perhaps just to put it within the public international framework, which the issues are that we would be looking at. Secondly, I will say a few things about the procedure, and again, they have been partly covered, but perhaps add a little shade of nuance on a few points. And finally, without going in, as it were, the substance, touching upon some of the points that John left open, as it were, for further discussions. I think I really find myself in an extraordinarily privileged position where all the hard questions have been covered and covered very well. As Tonya noted, the International Court was excellent timing, I think really confirming my theory that international dispute settlement revolves around UCL's lecture schedule, published a couple of hours ago, the order on organization of procedures. So some of the things that I was about to muse a great deal about, making a deep dive into the League of Nations practice has been resolved. So very, well, fortunate and unfortunate in a sense, because I would have been a bit wrong on both of the things that I would have predicted. But I, in academic honesty, I will just say what I thought would happen. In a compromise, I think I would have been slightly hawkish on one point and slightly more conservative on the other one. International Labour Organization is a specialized agency of the United Nations. And I think that is something that is, Tonya noted it, but it's worth hopefully, because it distinguishes this advisory opinion from many other advisory opinions. So, for example, the climate change advisory opinion, which is asked by General Assembly as a primary judicial organ of the United Nations. Here, to dumb down cultural references, the call is coming from outside the House. So we will have to look at the multiplicity of legal instruments to evaluate whether procedural conditions have been complied with. So we have to look at the United Nations Charter, at the ILO Constitution, other rules, as well as the relationship agreement from 1946. So each, as it were, separate island, as well as the bridge connecting them. It may also be interesting to note, even though I think that the order of earlier today has resolved most of the issues involved, we look back a bit at the League of Nations, again, point that Tonya noted, which provides us with a somewhat curious amalgamation of practice. On the one hand, 6 advisory opinions relating to ILO, including the 1932 opinion on employment of women in nighttime convention, very important. On the other hand, rendered in a very different structural context. So there, the opinions were asked, formally speaking, from within the House. They were presented by the Council of League of Nations itself. So I think that this is something that my institutional law colleagues will appreciate a great deal, trying to unpick which of the legal arguments fitting in the League of Nations are still relevant and which have been superseded by other considerations. The International Court of Justice, primary judicial organ, focus here is on advisory opinions, so it is not a contentious case, but rather a question being asked that on its own does not possess a binding character. And I think that that is something that probably from a public international law perspective, perhaps one of the more interesting issues, and I think brought out interestingly in the paper written by the employers organization. We are probably going to be guided in our thinking about the court's approach to procedural matters by 2 recent advisory opinions. The one, and we cannot but give a shout out to our good colleague Philippe Sands, who argued the case for Mauritius, the Chagos advisory opinion of just a few years ago, and a slightly earlier advisory opinion, again implicated by an external body. Even you have the ILO in the title, but it is not about the ILO, it is about the ILO Administrative Tribunal. So we have to, as it were, look at both of them to derive some materials. And the great pleasure of reading and preparing for this was really familiarizing myself with the highest caliber of international lawyers working for the International Labour Organization Secretariat, not surprisingly, in the line of Wilfred Jenks and all the great international lawyers. So quite a lot of in a sense, many of the hard questions have already been addressed in a great deal of detail. So first, the jurisdictional issue, and recall the intellectual construction that we have to satisfy the criteria set out in both islands as well as a bridge connecting them. So the question has to be properly asked by the international organization in compliance with the criteria set out in the relationship agreement, as well as fitting within the jurisdictional framework of the international court. And so here we have a quote from the first of the 2 advisory opinions I noted, which relates to a different relationship agreement, but one that is in its essential respects similar to the relationship agreement with the ILO, which was of course the first and the greatest from which all the other relationship agreements follow. So The question is whether these are legal questions which arise within the scope of the organization's activities. At least my reading, and I'm really happy to be corrected by those who know the internal politics, that this was not really an issue that was challenged even by those who were against the question being asked. If anything, it was a converse proposition, that it was too intimately connected with the ILO, as it were, to watch the laundry outside, so to speak. So it seems, at least prima facie, that jurisdictionally this seems to be broadly on safe grounds. And this is a point made by the ILO Office background report. It refers to the both questions, because at that point it was thought that the second question relating more specifically to the committee would also be asked. But the point seemed to be, as it were, still persuasive as it was put. And if I can just jump 2 slides back, if you see the fourth document from the bottom, where the employer secretariat made certain critical remarks on points that they disagreed with, even though they had some reservations about the way how jurisdictional issues had been characterized, it wasn't really a challenge on jurisdictional grounds as such. It was really getting to the what I think is really more substantial and serious part of the objection regarding the binding character of the advisory opinion. Then there's a point on admissibility. As John noted, there is a certain discretionary element in the work of the International Court of Justice. It is not something that has ever been exercised in advisory opinions, but in fact, in this advisory opinion, the court was very troubled, but for that case, it was troubled for different reasons. It was troubled for lack of equality of access, because individuals did not have access to the International Court of Justice in this setting, and therefore, in an essentially appellate procedure, only one party could present its arguments. But even in that case, the court found ways to render its opinion. Now, again, trusting the judgment of those who know on the politics, it seems that from the sort of description, an argument could be raised that internal discussions are not yet ripe and that it is premature for the court to render its opinion. And it does not seem to be the sort of argument that has had a success in the International Court. Note that even here, where the court really was very troubled indeed, it ultimately did not find that the request was inadmissible. The second point, and I know that this is something that has been resolved, or perhaps resolved, it has been addressed already, is the question of the timing. Something that is explicitly addressed by the rules of the court, something that was identified in the governing body's resolution and raised by the Director General. And this was a point when my prediction was a bit more, I guess, ILO friendly than the court ultimately came out with. So if you look, going into excessive detail at the 2 pending advisory proceedings, we might roughly say that, here you have about, one might think of about 1.5 years from the request, 2 rounds of written statement, oral proceedings, and ultimate rendering of the opinion. The most recent example where urgency was requested, the Israeli war case in 2003-2004 had 1 round of written statements and essentially half, a bit more, 3/4 of a year, half a year. So I think what I was trying to suggest that the timeline we are thinking about is between 3/4 of a year and 1/2 of the year, urgency seeming to suggest towards a narrower end. But, and I mean, I was going to suggest it, perhaps caution people from booking summer parties for celebrate the release of the opinion, because the court is very, very busy with 2 other very important pending advisory opinions, many contentious cases, many provisional measures being requested, interim measures. the outgoing president of the court, Judge Donoghue, made a rather unprecedented intervention in the Legal 6 Committee this year, noting the budgetary challenges of the court in light of the ever-increasing workload. So that was my somewhat skeptical note. And what we get out of this, I think actually in terms of timing, it seems virtually indistinguishable from the non-urgent climate change and Israeli cases. We again have 2 rounds of written statements, and it seems to be, as John said, we are really looking at 2025. So it seems like about the same 1.5 years. I mean, it could be that some people might have taken the view that, well, right to strike has a certain urgency. Perhaps climate change and peace in the Middle East are also of some importance to the international community. But we can only speculate about the sort of thinking that went into international court's decision of today. So, as it were, the timeline is set. We don't know the oral proceedings, but one might expect perhaps end of 2020, end of next year, beginning of the year after that. The next point, and this is where I was slightly more conservative than the court, or perhaps at least cautious about the confidence with which the ILO office was coming at it, was a participation by workers and employers organizations. And the background report comes out quite strong on this issue, essentially suggesting that this is a point where procedural pragmatic considerations will push aside the ratione personae considerations. So Article 66 might speak about states and international organizations, but you shouldn't take these things too literally. And what I was going to suggest, even though, you know, the office background report makes an argument, and there's another paper from about a decade ago which makes an argument even more strongly, that there is ground for caution. We know that individuals are not permitted to participate in the proceedings. We know that Practice Direction 12 explicitly puts the non-governmental organizations at a slightly different procedural way. You know, in practice, they would have a particular place in the Peace Palace where people can go and look at what they have written if they so desire, but they wouldn't really be participating in formal terms. Whether Kosovo and Israeli war advisory opinions are as relevant as has been suggested, I have some doubts. And the Permanent Court of International Justice reform was operating under a significantly different institutional framework. Again, here, what I was about to suggest was, as Andreas Paulus puts it in the leading ICJ statute commentary, perhaps ILO constituent bodies, the organizations, fall under the particular context of something into which it and ICRC might fall in. So entities that to some extent might have rights and obligations within the particular setting. So one would not really be opening floodgates here. It's interesting that the pitch that ILO went for was a narrower one. So it wasn't driving through the procedural convenience angle, which would have been a very broad proposition. Governing body of the ILO put it in narrow terms, emphasizing the cumulative and narrow elements. So the unique tripartite structure, and also not all organizations, but those with consultative status. So really a rather narrowly delineated setup, something that ILO Director General's letter brings out explicitly. And that is precisely the rationale that is replicated in paragraph 4 of the order published today. Particular tripartite structure and particular 6 organizations noted there. I think as a side note, the fact that other organizations have not been noted in this order does not mean that they cannot request from the International Court. As indeed in the climate change advisory proceedings, many organizations that take very different views on the matter. OPEC and Pacific Community, for example, have requested and have been given ground, so to speak, to participate. But I think that there is a degree of caution, and I think a rather much more conservatively sensible approach the way how it was put forward. So perhaps there's something to be taken away from there. Now, what is the legal effect? There's an office note on the webpage which is rather confident about the legal effect of advisory opinions in paragraph 3. Employer Secretariat is, as you can see, less persuaded by the argument. So where do we stand there? As a general proposition, advisory opinions, unlike contentious cases, do not impose, as it were, ex officio binding obligations. It doesn't mean that they are unimportant. They are extraordinarily important, but as subsidiary means. So they tell us what the content of the binding rules are. In a way, the beauty of res judicata, that actors to which they are addressed have to comply whether or not the court is right. They have to comply because it is a judgment. An advisory opinion in international law would be a way of explaining what the content of the obligation is. Now, states and other actors might add an extra layer, something that is not automatically binding, may pre-agree to treat as binding. And that is something that is often happening in the context of international organizations. They literally say, last advisory opinion will be binding. Is that something that we have in the ILO framework? And this, I think, again, would be interested to hear reactions from those knowing the inner kitchen. Seems to be a point on which reasonable people disagree. Article 37(1) of the Constitution speaks about referring for decision to the International Court. It doesn't say that the opinion would be binding. Article 37, paragraph 2 uses the language of binding opinion of the International Court of Justice in a different setting in relation to judgments to particular tribunals established. So this seems to be a point on which an interesting debate could be had. Now, it doesn't mean that if an opinion that is not binding is not important. Employers themselves say that in practice it has been, or the previous ones have been adopted in a consensual setting, but it does raise interesting legal questions. And this really seems like one of those things that could be international lawyers' bread and butter. The legal office has a lot of practice by relevant actors who seem to be saying things that are almost on the point, but possibly not always precisely on the point. So I think that this is certainly one of the points TBC. Now, really just the last minute or so, what to say about substance? And on substance, I want to say 3 things. The first is, John is absolutely right. Of course, he's very helpfully set out the principles of interpretation reflected in the Vienna Convention framework. I would probably add 3 points that struck me as an international lawyer. One is how elegantly the question has been drafted. So it is not drafted by explicitly using the term of interpretation. Under, it seems to me, encompasses within it arguments of both interpretation and application. Because it is also possible to take a view that an argument of interpretation does not answer a question one way or the other, but the application of the instrument necessarily, or in most circumstances, implicates a certain right. I think the fact that the focus, the framing is as under, strikes me as very good. It perhaps in some ways really building on the employment of women. Good example where also there's a question about whether a convention applies to certain circumstances. So that I think is very nicely put and opens a perspective for different kinds of arguments. The second and third point relates really to subsequent practice, and particularly the expert work of the expert bodies. And these will be, as John said, very hard and interesting questions to be asked. I had a look, and the International Law Commission's conclusions from 2018 on subsequent agreement and practice in relation to interpretation, adopted before my time, so I have no particular knowledge on them. Notes in Article Conclusion 13 on expert bodies, the ILO Committee, but then excludes it from the coverage because it has a misfortune of being an organ of the organization. It says this doesn't exclude that the substance of the present draft conclusion may apply mutatis mutandis, which I think, having been chair of the drafting committee, I have a bit of a sense of what that means. So certainly still a debate to be had. Another debate to be had, and this goes to the subsidiary means angle, is whether and how we look at the weight to be given to these bodies. Are they judicial bodies, analogizable? Are they collective of learned scholars? Are they a third unenumerated category? Without, I didn't put it on here, but the International Law Commission's work on subsidiary means for determination of rules of international law has suggested this year that there is a third unenumerated category, as it were, implicit in Article 38, paragraph 1d, where it was not addressed in substance this year. It could cover human rights issues. So some members suggested. Also, to be fair, the views of states in the Sixth Committee were varied and of course would be taken with utmost seriousness. So these are interesting points, just to sum up, and I think that they would touch both upon very important questions of labor law, but also hugely important questions of public international law.
Well, excellent. Before we take questions, can you join me in thanking our speakers for some fantastic point of view? Thank you very much. Excellent. Yes. So Martin and I will swap seats just so that I have access to the screen. So those colleagues who are attending online, please stop sharing. If you can please, yes, type your questions in the Q&A, and I will I will look at them and try to select or read them out depending on how long they are. There are some long questions there. I'm going to have a look at them before I share them. Let me see if there are questions in the room. Yes, one question there. Would you like to introduce yourself, if you don't mind, before you ask?
My name is Sam. Originally from Uganda, but I've been in Istanbul for the last 4 years. Originally, I came as a student. I was in College of University. But my understanding, I think that at the advent of Margaret Thatcher's success was Devon's report on strike and the importance of collective bargaining, by which he concluded that to thaw the sharp fronts of confrontation, at which point all the time workers will win. Therefore, to avoid confrontation with that nature, that collective bargaining was completely acceptable in any government that calls itself liberal, of which Britain is. And therefore, I wonder whether, by looking at it, whether the sharp fronts which they call, which that means strike, sharp fronts which strike. So, as the Lord was trying to say, the strike is not consistent with the collective bargaining. Please, can you explain it further what that means? Because I don't understand exactly whether collective bargaining is in, because that's the only way. I mean, the only power they have, unions have, is a strike. Because collective bargaining means what? I mean, you give me this, you don't give me this, so if I refuse, or I don't accept it, what does it mean? Thank you very much.
Would you like to answer, or shall I collect a couple of questions? There are
A few questions.
a few questions. Okay, great. Yes, one, two questions, and then I'll take the two. So I'll collect a few questions. I'll take 3 questions from the room and then 2 questions from the chat. So let's take the 3 questions from the room first.
Thank you very much for these insightful presentations. I was just sitting here wondering what, from my point of view, would be the potential downside here. What happens if this case goes the way that most of us would be find unwelcome, and that the ICJ says, well, plain and obvious meaning is it doesn't mention the right to strike, so there is no right to strike under that convention. So my question is, what then? Is this a disaster, or is it just an opportunity to regroup?
Thank you. And there was a third question. No? Okay. So, Jamie, yes. A third question in the room, and then.
Thank you so much. I'm Jeannie. I'm a graduate student here studying at UCL Laws. I was wondering if any of the panelists thought that the recent massive gains in the US with relation to their unionization efforts, just from major unionization efforts at Amazon and Starbucks, which were notoriously anti-union, and the recent gains from the Hollywood Writers and Actors Union and the United Auto Workers, if you think any of those developments might have some sway in the ultimate decision by the ICJ. Thank you.
Let's answer these questions, but briefly, please, with if you can, and then we'll take the 2 questions. There are 2 long questions here, 2 really good questions here too. Tonya. Yeah.
Okay, so in response to the first question as to why you might want a right to strike in addition to collective bargaining, or to back it up, I mean, certainly collective bargaining provides employees, workers with collective strength, so that it's not just one worker up against an employer or a group of employers. But there isn't that much leverage that comes with that. And so the use of a right to strike, I think, for a very long time, that expression that, you know, without a right to strike, collective bargaining is collective begging, has now been traced back to the 19th century. I mean, it's a very old idea that if you don't have that, but I don't think the right to strike is only about that. I think it is actually also about protesting about economic and social conditions. I think it has a democratic element as well that's really important. So it's worth protecting on a variety of levels, but I'm sure others will add into that. Hugh's point about the downside, yeah, there is a huge risk here. I think we're all acutely aware of the importance of doing this well and how much there is at stake. As Virginia said, formally speaking, perhaps this isn't binding under international law, but in the terms of the ILO, where, as the employers group has said, the International Court of Justice is given the exclusive right to interpretation, I think it really does matter. The only thing is there'll be a degree of certainty. And Jeannie's point, I would love the fact that, you know, the right to strike is topical and important, and that political context to be recognized, but I don't think that's going to be relevant. I think it will be pure legal arguments.
John, yes.
Yes, well, I agree.
Briefly, if you can, please. And because,
Yeah, I agree with what Tonya said about the right to strike. Of course, the need for a right to strike goes much broader than collective bargaining, and the European Court of Human Rights has recognized that there is a right to strike which over political issues and social conditions and so on. But so far as collective bargaining is concerned, I mean, the reality is that without some leverage, there is no bargaining. It's simply putting a case and hoping for the best. And I agree with Tonya as well that if we lose this, it'd be an absolute tragedy but I say we, but it's not us that's going to fight it. I'm very pleased that it wasn't me that advised them to go to the ICJ anyway. So that was a decision that was made by the workers' group. Well, obviously felt that well, not just by the workers' group, but advanced by the workers' group. Who obviously felt that unless something decisive was done, the machinery of the ILO would be paralysed. So something had to be done. And if the case does lose, well, it won't be the end of the ILO. There'll no doubt be a huge battle to establish a right to strike in a new convention or something of that kind. And just on that point of binding in international law, I was very interested in what Martin had to say about that. It won't be binding automatically, of course it won't. But I envisage, and Martin's might correct me in this, but I envisage that once the opinion has been given, it will then be adopted by the governing body and put to the ILO conference, who will then ratify it or not, as the case may be. And once ratified, it may not be binding in international law, but it will be binding so far as the ILO is concerned. And finally, on the SAG-AFTRA and the WGA disputes and the United Auto Workers in the United States, I'm not sure that this issue really is affected by those disputes. Very good results were achieved in those, and it's interesting to see the upturn in industrial action in the United States, just as there's been an upturn in industrial action in the United Kingdom as well. But the merits of these disputes really don't reflect on the legal issues that we have to contemplate this evening, I think.
Yes, final question. Yes, final response. We have a lot of questions here in the...
Right, so I will be very Polonius level brief. Can ICJ reject views of committees? Absolutely. In Qatar Arab Emirates, it said that a committee on elimination of racial discrimination was wrong to conclude that discrimination on basis of nationality was racial discrimination. So it has done so. It can absolutely do so. It is not inconceivable. Binding, I think that there are probably three slightly different layers here. Binding, as it were, ex officio from the character of the opinion itself, which it is not. Binding from the perspective of the recipient. Office has asserted that ILO constitutional theory and practice makes it binding. So that is a legal question. And the third layer, whether it is accepted in the consensual process as it has always been. And the fourth layer, which is a slightly different one, whether it is an authoritative explanation of the content. So I think that they are just these lawyerly nitpicky things to distinguish. Finally, just as a point of caution, we are speaking about the universal instrument. So it's important not, legally speaking, look at it from the perspectives of one region or from one country. So the perspective of UK, US, and European Court of Human Rights is not more important than that of African Commission or Inter-American Court or Colombia or Chile. In the universal setting, these things do matter.
Great. So we have. I'll see how many questions I can take from the list here. I'll start with Phil Sirpis, who was the first one and has been waiting patiently. Phil is saying if he's inviting the panelists to speculate, how do you think the employers might react to a decision confirming that the right to strike is protected under Convention 87? Would that settle the debate, you think? Tonya or John perhaps can reply to that one.
I mean, I think that the employers will not take this lying down. I think even if they lose the case, they're not going to walk away from their position. But I think it will be harder for them to undermine the supervisory bodies in the way that they have been doing. So I think that the claim that they have had is that these bodies have been acting in some kind of illegitimate way. I think they have to drop that argument. They may yet be creative about others.
We will be running out of time, but we can stay, I think, for a few more minutes, if you don't, 5 more minutes, if you don't mind, because there are some really interesting questions here. Whether, for example, I also had this question by Yuri Varlamov, whether it is whether you think that the ICJ might limit itself to discussing the right to strike, the purpose of the right to strike only for collective bargaining process, interpreting Convention 87 as not covering other strikes, such as political or sympathy strikes.
Again, it depends on what the employers actually raise. So
Yes.
there is a risk, because of the kinds of reasons that they gave for the 2012 walkout, that they will raise this as being fundamental as an issue. And as John said, they can rephrase the question.
Yeah.
But if they were only to answer the question as to whether the right to strike arises under Convention number 87, they wouldn't have to address that. And in that scenario, they would be acting appropriately to say, and the International Labour Organization supervisory process, both expert and tripartite, should continue to monitor that. That would be a much more sensible approach. I would be amazed if they decided to follow the employers, especially given that I don't think governments will prompt them to do so in going into political and sympathy strikes.
Can I ask, unless you want to add something, there are two more questions.
Just add one point on that. The question asked whether it might be possible for the ICJ to exclude political strikes. I think it'd be very, very difficult for the employers to ask the ICJ to do that, because it's not a position that the workers group necessarily wants to defend. I mean, the issue here is under Convention 87, which in its preamble refers to the principle of freedom of association to be a means of improving conditions of labor and of establishing peace. Well, I suppose the latter part might extend to politics, but this is in the context of industrial relations. So I think the ICJ is more than likely to say, well, that's a battle for another day. That's not what we're here to decide.
Two questions. Two people are asking whether it's possible for trade unions, national trade unions, to intervene, or national governments to intervene and in support to make an argument in this case. Can they make an intervention, Martins?
So, I mean, I didn't to bring up the particular paragraph, but the first paragraph of the order says that parties to the convention and ILO necessarily fall within the number of the actors who can furnish information. And I think that would be an interesting question, how actively states participate. If we look at the PCIJ time, they were not extremely active there. And in the ILO context, I think the office notes that they were fairly passive. I mean, as I said, the fact that they haven't been specifically invited doesn't mean that other actors cannot request the ICJ under the same principles. But as I said, the fact that ILO itself pitched a request in rather narrow conservative terms, and recalling, I think, perhaps really the caution about floodgates and the extent, I think these are arguments that can be made, but they have to be carefully thought through and pitched in ways that really, to some extent, replicate the framing of the ILO and the court.
John, and then I'll take two final questions. And
it's not a contribution; it's a question from Martins. I was intrigued to see that that the court didn't confine the contribution, the statements, to the three parties and say, we want one statement from the workers group, one from the employers group, and one from the government group. Because it seems to me that it's left it open for fragmentation. Is there some reason for that, or did that surprise you?
So in a way, it was precisely what had been requested.
Yes.
I mean, to that extent, I mean, I think that the one institutional question that I had was how closely, how relevant the PCIJ practice would be, which was fairly flexible. And I think that there were a couple of times when they also asked 5 or 6 organizations. I mean, to the extent that there were organizations that were drawn in a narrow way, general consultative rights, and on its face neutral criterion and benchmark, to be articulated in a way that prevent floodgates. So it seemed overall consistent. I mean, as I said, if the court had gone in the Andreas Paulus direction, that everybody who is in some way involved in the process and capable, kind of if we go to these 3-4 pages in the annex to one. But as I said, it will be interesting to see whether other actors make requests nevertheless and how the court deals with them.
Yeah.
Yes, so yeah, unfortunately, we will not be able to take any more questions. There are further questions here on the right to strike and whether it can be, it is viewed as part of customary international law, etc. And other interesting questions about the scope of the right to strike, whether the ICJ will determine it. I think some of them have been touched upon, but unfortunately, we cannot answer everything tonight. We simply wanted to open the discussion and start learning from our brilliant experts here about this new development. But so I'm very sorry that I will not be able to take more questions from here, but I want to give the panelists the opportunity to make some final comments before inviting those of you who are here for a drink. There is a drinks reception.
So I was just going to say that the very first case, the first reference to the Permanent Court of International Justice actually did involve, you know, the ICFTU and others. So, I mean, I think that there is, and did involve a national trade union as well, but it was about the representativity of the Dutch worker delegate in that context. So it made sense. But I do think there is a real danger here that even as the ILO has actually put this forward and set out the parties, that having the ITUC and the WFTU and the OATUU providing the workers' group case is unusual. And also because the ITUC acts as a secretariat for the workers' group. So there is already fracturing, and I think I would probably discourage national trade unions from intervening in the process, because otherwise they're likely to dilute the effect of the arguments. So that would be my concern.
John, and then Marcus.
I'm going to pursue with Martin afterwards this question of the parties, because the question of representation is also related to the question of accepted practice and accepted agreements, for whom the parties must surely be the tripartite bodies of the ILO. But my final point was just, and Virginia has taken one of the questions on customary international law. We didn't touch on it because we haven't got time to touch on it. That will be, without a doubt, an issue before the ICJ. It won't be a primary issue, because I'm sure that the workers' group organizations will not put that at the forefront, but it will certainly be an argument that they will be advancing, and that requires an enormous amount of material, looking all over the world, judicial, academic, and so on.
Probably the final thought, and really, so I suppose thinking through the pros and cons of a message being consistent, if singular, in the actors who articulate it, from being perhaps a bit messier, but also reflecting to some extent of the pluralism. And I think that is a debate that has been had in different settings in international courts and tribunals in relation to advisory opinions, to some extent in relation to intervention by states, to the extent that there is a degree of disagreement, even if with an underlying substantive agreement. It's really a tactical question, whether it is better for that messiness to be articulated in procedural terms, or to have that pristine consistency that might not necessarily be there in the legal political world, and reasonable people will disagree. That's probably my final pitch.
Okay, well, I hope that you enjoyed this discussion as much as I did. It has been a fantastic opportunity to hear by top people in the field about very difficult labor law, very simple for us, but very challenging apparently politically and legally at the international level. Top labor law scholars and practitioners and international law scholars and practitioners. It's been a delight to host this panel as here at UCL. Thanks everyone who participated online. There will be a recording of the event and there will be further opportunities to discuss it. We simply wanted to have this first event to open the discussion and see what are the big issues that we need to think about in the coming months and years. If you want to join me to thank again our excellent speaker. Thank you everyone for your participation.